Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, listen, we got big news, and it's big good news for once. It is a huge win out of the Fifth Circuit Court of Appeals, and it relates to bump stocks. Big ruling as it relates to the bump stock ban that ATF introduced a couple of years ago, basically rounding all of those devices up. But when you take a look at the language of this opinion, it may have some very far-reaching implications for other battles that we have right in front of us. So today, let's spend a few minutes, get you all up to speed, and talk about huge win on bump stocks and what that means for pistol braces as well. Okay, so the case we're going to be talking about today is Cargill v. Garland out of the Fifth Circuit Court of Appeals in beautiful New Orleans, Louisiana. Now, I will tell you that this opinion was emailed to me late this afternoon by my Oregon State warrior, Jerome. For those of you who've been geeking out, especially on ballot measure 114, you know what an absolute asset Jerome has been to us here at Washington Gun Law. So this video comes compliments of our Oregon warrior down there. So thanks, Jerome. Listen, this is a huge case. This is a huge case because the Fifth Circuit has ruled that ATF's banning of bump stocks after that horrible shooting in Las Vegas was in fact unlawful and has ruled in the plaintiff's favor there. Now, not only have they ruled that it's unlawful, they've done so on multiple grounds, and then they have declined to make rulings on some other arguments that Cargill was raising here, but did spend a few minutes and put on paper what they kind of think those rulings would have been. And so there's a lot of roadmap here and a lot to digest. We're going to try to take some of the real nuggets out of it, break it down for you in simple English so you can understand the importance of this ruling and what it means for us moving forward. Okay, so like we said, Cargill here raised several very effective arguments, and I want to take each one of them and kind of dissect it for you because I want you to understand what all this means. The first argument he said is, hey, you know what? Listen, ATF lacked the authority to even make a rule on this. You see, the statute, which defines machine gun, 18 United States Code Section 922, yeah, that statute's pretty clear. It's pretty unambiguous, and for that reason, there was no reasoning to even make a rule. Now, just to refresh our memory, the applicable statute, 18 U.S.C. Section 922, defines machine guns as, the term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The term shall also include the frame or receiver of any such weapon, any part designed and intended solely and exclusively or combination of parts designed and intended for use in converting a weapon into a machine gun, and any combination of parts from which a machine gun can be assembled if such parts are in the possession or under the control of a person. And what the Court of Appeals did, and I got to give it up to the justices here who wrote this opinion, very detailed opinion, but they went through the actual function of a semi-automatic trigger versus an automatic trigger and the huge difference between those that have sears and those that have what we sometimes call auto-sear technology. And the court came to a finding which is factually correct and technologically correct, that even with bump stock technology, the trigger is in fact being activated for each pull of the trigger. Now, there may be some mechanical assistance in increasing the rate of it, but the trigger itself is being activated each and every time a round is coming out of that barrel. And for that reason and that reason alone, bump stocks do not constitute any component of a machine gun under the plain, very statutory definition. The court defined Cargill's argument and their position on this as follows. He now challenges the legality of that regulation, arguing that a bump stock does not fall within the definition of machine gun as set forth in federal law, and thus that ATF lacked the authority to issue a regulation purporting to define the term as such. Cargill is correct. A plain reading of the statutory language, paired with close consideration of the mechanics of a semi-automatic firearm, reveals that bump stock is excluded from the technical definition of machine gun set forth in the Gun Control Act and the National Firearms Act. And listen, not only is that huge, but the court goes on with further analysis and further justification for the ruling and really effectively covers their bases here. Because what they're saying is that when you take a look at this portion of the statute, any part designed and intended solely and exclusively, or combination of parts designed and intended for use in converting a weapon into a machine gun. So what the government is saying here is, hey, that encapsulates bump stock technology. What the court, and very wisely said, is no, wait a second. You see, if we have a criminal law, and it's subject to two reasonable interpretations, then the rule of lenity applies. What is the rule of lenity? Well, it's another one of these geeky legal terms, and we may do a video on it altogether separately. But the rule of lenity says, listen, with a criminal statute, if the statute is subject to two reasonable interpretations, the court shall adopt the interpretation that was proposed by the defendant. That's why we call it the rule of lenity. The rule of law will always be more lenient to the defendant when it is subject to two reasonable interpretations. So now we have the court saying, hey, it doesn't fall underneath the statute anyways, and then maybe even if it does, the rule of lenity controls. What does the government come back with? Well, they come back with the same thing they always do, which is the Chevron Deference. Okay, now we've talked about the rule of lenity. Now we're talking about the Chevron Deference. What is that in a nutshell? What that is in a nutshell is when we have federal agencies that are tasked with supervising and overseeing particular industries or areas of commerce, we should give great deference to those agencies when interpreting what terminologies mean and how things work. Now, that is all fine and good, and God knows the ATF has been doing way too much of that lately. But the court was not persuaded by that for three reasons here, and this is important. Number one, the government, even at the lower levels, the lower courts, had never raised any type of Chevron deference defense. So that's strike one. Number two, when we're talking about statutes that impose criminal penalties, like, being in possession of an unlawful machine gun, being in possession of an unlawful short barrel rifle, for example, then we don't allow any Chevron deference, because in order to ensure that we protect a defendant's due process rights, the rule of lenity is the correct rule to apply in criminal statutes. And then finally, and this is really important, why should any deference been given to the ATF? Because when we take a look at the history of them on bump stocks, the ATF specifically stated, hey, these bump stock technology, this does not constitute a machine gun. This is perfectly legal. And thousands and thousands of people lawfully purchased these products. Now, we end up having that terrible mass shooting in Las Vegas. There is evidence that bump stock technology may have been utilized in that shooting. And even though Congress has not one but two bills kicking around to ban this, do things correctly through representative government, no, what does the ATF do? The ATF runs to the front of the line and says, no, we got a better idea. We'll just do it through rulemaking. And I will remind everyone that was done at the bequest of then President Donald Trump. So what the government wants is to give deference to an agency, the ATF, who initially said, these bump stocks are fine, then later said with political pressure, these actually constitute machine guns. And an agency that is that wishy-washy, an agency which shifts that much with the political winds or succumbs that much to political pressure should really not be given deference to interpret much of anything. But in page after page of rejecting the government's request for the Chevron deference to be applied here, the court made a very particular ruling that I think bodes very well for what ATF is trying to do on pistol braces as well. The court specifically stated, finally, we note a third reason why Chevron deference does not apply in these circumstances. That ATF has adopted an interpretive position that is inconsistent with its prior position. To apply Chevron here would contravene one of the rule's central purposes, to promote fair notice to those subject to criminal laws. If we were required to defer to the government's position, the government could change the scope of criminal liability at any time. Indeed, that is exactly what it has done here. And that's the point I'm really trying to make here, is if that's the rule of law as it relates to these bump stocks, then how is that not going to be the rule of law as it relates to what ATF is trying to do with pistol braces? And then finally, Cargill also challenges under the whole concept, and shocking concept here, that, hey, you know what? ATF doesn't even really have the authority to be making laws, because we got this little thing called, the separation of powers, and this is supposed to be through an act of legislation. And let us also remember that there were 2 bills kicking around in Congress that could have banned the possession of bump stock technology. But before Congress could ever act on that, ATF, as I mentioned, just jumped to the front of the line and said, no, don't worry, we'll take care of it. Now, when the court had an opportunity to address this issue, they passed on it because they had already ruled on multiple grounds that Cargill was going to prevail. Where most courts, however, would just pass and maybe do it in 1 or 2 sentences, the court here did take time to kind of lay out a roadmap of what they think about ATF's broad overreach into lawmaking. This is what the court had to say. Cargill also argues that the passage of the final rule is an exercise of legislative power in violation of the Constitution's vesting all such power in Congress, citing to, by the way, United States Constitution, Article 1, Section 1. Some have expressed serious concern at the ATF's lack of explicit authorization to interpret criminal statutes as such. We should feel deep discomfort at allowing an agency to define the very criminal rules it will enforce by implicit delegation. Such delegation turns the normal construction of criminal statutes upside down, replacing the doctrine of lenity with the doctrine of severity. But, as mentioned, the court did not come to a ruling. Essentially, this particular argument was deemed moot. That is, hey, we've already decided the issue on a bunch of other grounds, therefore we don't need to reach that ground. The court specifically stated, we do not reach this issue because we do not have to. But if we did, it would only provide more support for the conclusion that a semi-automatic rifle equipped with a non-mechanical bump stock is not a machine gun for purposes of federal law. So, like I say, the case is Cargill v. Garland. It's out of the 5th Circuit Court of Appeals. We're going to put a link for that down below. And I want you all to pay careful attention to the ruling. Geek out with it a little bit because, listen, there is a lot to digest there. I've only had a chance to read it a couple times. I'm going to go through it some more, see if there's other nuggets we can pull out and do some other videos on. I want to thank our good friend down in Oregon, once again, Jerome, for turning us on to this case so quickly. In the meantime, listen, if any of you have any questions about this or what's left of your Second Amendment rights, you know the drill. You can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.